Good afternoon, Your Honor. Justin Zade appearing on behalf of Ms. Williams, present standing to my right. Can you say your name?
Jessica. Mhm. Sorry.
Apologies, Your Honor.
Good job. All right, I have before me, did you state your name, ma'am?
Jessica Williams.
All right, I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of disturbing the peace, a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Jessica Williams.
All right.
Sorry.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, Your Honor.
In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that with pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form.
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
September 25th, 2025, at the location of 1150 Paddock Place, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I was in an altered mental state and I
Pardon?
lunged. I was being cared for by an EMT in an altered mental state. And at one point I lunged toward an EMT
Okay.
in the ambulance and acted inappropriately.
And the altered state was an voluntary state?
Yes, sir. Yes, sir.
Okay. And when you did that, lunged at the EMTs and didn't cooperate with them, it disturbed the peace and repose of the immediate area surrounding you?
Yes, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if between the time of the plea, or from the time I accept the plea and the time of your sentencing, that if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Hold on a second. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be March 11th, 2026, 9 a.m. That's before me. Counsel, approach briefly. Versus Dion Lyons.
Definitely, Your Honor, Attorney Kim, 71061, on behalf of Mr. Dion Lyons. Mr. Lyons, state your name for the record.
Dion Lyons.
And That one? All right. Did counsel have a copy of this?
that the bond report, yeah?
Redwood toxicology report.
I have that, Judge. Well, this is what I have, the progress report, yeah. That's what I have. Yeah, that's what I have as well, Judge.
So you don't have the Abbott Laboratories report?
I don't have it either.
Can I get copies for them? So let me pass the matter so you can go through that with your client.
Thank you, Judge.
We're waiting on the other. Who's here? What are you talking about? We're waiting for his client. I already called it. Where were you?
Honestly, I have no idea.
Same all the time things.
Just, you guys need to keep up with me. Alan just turned on me these three times during that whole thing. You could have stuck by my side. No, that was yesterday. I did. I was doing random acts of kindness everywhere yesterday.
Yesterday?
Isn't that right, Mr. Bates?
Yes.
See? That one.
Yeah.
See, Bates agreed. What? But he felt a random match for where he was. See? Some people just don't appreciate it. No, I got stuff to. Yes, Gordon. Yes, if I can come. Court recalls the case of the people versus Dion Lyons.
Alexander, on behalf of the people.
And again, y'all are Attorney Kevin Masson, P71061, on behalf of Mr. Dion Lyons. Mr. Lyons, state your correct.
Dion Lyons. All right, we have checked and shared with counsel sidebar. I'm looking for their actual written response. Which is what I kind of suspected. There's one drug in here that may show up as opioid, but would not be picked up on our test. That's a simplified version of the answer. Would not test positive on our test as an opiate. And specifically, Community Corrections informs me this is not an opiate drug, mainly because selling that at a gas station would indicate that that gas station would be charged with a felony. They were selling a narcotic. But then additionally, specifically, they very clearly indicate it would not show up on our drug screen as an opiate. So, how many of these supposedly did you buy?
So, you want me to respond, Judge?
Yeah.
So I talked to my client, Judge. He said he was taking them for 5 days straight, you know.
Well,
And may I address the bond issue, Judge?
yes, you may.
And so, you know, first and foremost, I don't think Mr. Lyons is trying to evade the court in any way, shape, or form. I did have a in-depth conversation with my client, and Judge, he's still adamant that those were the only any type of drug or I don't want to say prescription, but those are the only things that he has consumed. And I know what the court's position is. I know what the test says, but my client is adamant that that's it. What I would note, Judge, is that prior to this test, he had tested negative. On the 10th, he tested positive for opiates. However, he tested today with Community Corrections, and from my understanding, it was negative. That there's nothing in the system as of right now. My client is adamant that there will be nothing in the system going forward. I know that a report showing that he had opiates is technically a bond violation. But my client has been trying to wean himself off of any type of narcotics Since the day he got tested, when he had the Suboxone in his system, which is clearly no longer in his system. He stopped with the THC and the marijuana. That's why no THC is in his system. And now we're left with this particular incident. And so, Judge, I guess what I'm asking the court for, given the fact that he did technically test negative today, if the court would give him one more opportunity to prove himself that he can stay clean, that he can stay negative, and not consume any type of narcotics of any sorts from this point forward. I believe that Mr. Lyons will do so. His mother is scheduled for a major surgery where he is set to be her caretaker. And so I'm hoping the court will continue his bond to allow him to do that as well. But with that being said, Judge, I'm asking the court not to revoke Mr. Lyons' bond, but to give him one more opportunity to prove to this court that he can stay negative with his testing. Yeah.
Anything from the people?
I just have concerns. I know the last time we were here, we had some concerns about the stock, given they didn't have the prescription. And we're working through that, and I understand that. I'm concerned now that we're here, it's opiates. Community correction says they don't match with what the test results are showing the product that he brought in, so I have concerns.
As far as the case, what do we want to do on the case?
Defense counsel is prepared to set it for a preliminary exam.
I won't, here's what I'm gonna do. I'm not going to at this juncture set it for preliminary examination. I'm going to adjourn the probable cause conference out 1 week. February 26, 2026 at 9, or as your Zoom invite indicates. At that time, I'm also, if you want, I will set a hearing on the bond violation. I'll get the people over here, let the prosecutor know. I'll get the people from community corrections to testify if we need to regarding that drug and what shows up on their test results. I'm going to indicate to you, young man, I'll be honest with you, with what I know right now, I may learn something later. I don't believe you. I think I'll tell you what I think is happening. I think you're trying to get yourself off of the drug. You were taking the Suboxone. You have an opiate addiction. You were taking the Suboxone. You want to get yourself off of the Suboxone. That is clear. You want to have yourself clean, and you had a moment of weakness. And that's why an opiate is showing up. Now, you can shake your head all you want. I've been watching. I've been doing this for a long time. And you can come in here and then try to show me something that you say shows up as an opiate. Our testing is so sensitive. I mean, our testing distinguishes between heroin, fentanyl, and an opiate. We can distinguish all of those different drugs as to what somebody's taking. And so this product would not show up as an opiate. And at some point, quite frankly, you're going to have to come to the realization that, and I think you're an addict. And you're going to have those moments. But the problem is, when you have those moments, you're going to have to be honest about it. And I don't think you're being honest right now. And I think there may be other reasons why you're not being honest, but you're not being honest. Because the only way that you're going to manage your addiction is if you are honest. So I will set this for a hearing. Counsel can let us know if he really wants to go forth with the hearing, but people would be expected to have the people here. I've set it out 1 week actually I'll set that at 3 p.m. for the hearing. I'll set his PCC also at 3 p.m. At this point, however, your bond is revoked. Defendant's remanded pending that hearing.